I'd like to welcome all our participants today. My name is Justin Alexander Halim from the International Law Moot Court Society of Fakultas Hukum Universitas Indonesia Externals Division. And today I have the privilege of serving as the Master of Ceremony in the second installment of the ILMS FH UI webinar series with the theme of Building a Career in Alternative Dispute Resolution, Role of Counsel, Arbitrator, and Academic. Today's event will be moderated by Heru Anashahdio, ACI ARB. Heru is an alumni of the Willem C. Vis Commercial Arbitration Moot, with his team being the champion of the 10th Indonesian rounds of the moot earlier this year. His other achievements also include that of winning runner-up in the International Humanitarian Law Moot Court Competition and honorable mention in the Nanyang Technological University Model United Nations. Heru was recently awarded the title of Most Outstanding Student of the Faculty of Law, Universitas Indonesia in 2020. Today's guest speaker will star Dr. Harald Sippel, MBA, SFBIAM, FCI ARB. Dr. Sippel is the Academic Director of the Bali International Arbitration and Mediation Center and a Senior Foreign Counsel at Schindler Law Firm. He has specialized in ADR for over a decade and has been involved in over 2,000 arbitration, adjudication, mediation, and other ADR proceedings. Moreover, he has seen arbitrations from the perspective of counsel, arbitrator, head of legal services at an arbitral institution, and in-house counsel. So surely he is one of the most qualified people to talk about today's topic. So today's rundown will consist of opening remarks by the president of ILMS FH UI, Fadira Mediana, before she passes the baton to Dr. Sippel for his opening remarks and subsequent presentation, which will take 90 minutes, followed by a dedicated question and answer session for 30 minutes. Throughout the webinar, participants are encouraged to ask questions and also make comments through the Q&A box located next to the participants feature of your Zoom account. Please use this Q&A box to ask the committee any technical issues you might experience. Selected questions and comments will be addressed either throughout the presentation or in the dedicated Q&A session. In addition to questions and comments, we will be making use of the poll feature in today's webinar, so please actively participate by choosing the option you deem most appropriate. Prior to handing off to the president of the International Law Moot Court Society, FH UI, I would like to remind participants of two housekeeping rules for today's webinar. Firstly, that participants should rename their Zoom display names to their institution's acronyms as stated in the guidelines, followed by their names. And secondly, that participants can ask questions and comment to the speaker's presentation through the Q&A feature using a Q or a C in front of the questions and comments respectively. Last but not least, we would like to inform participants that we would be handing out certificates of attendance for today's webinar attendees. So now, without further ado, I will give the floor to Fadira for her opening remarks.
Thank you, Justin. Good afternoon, everyone. My name is Fadira Mediana, and I am the president of International Law Moot Court Society of Faculty of Law of Universitas Indonesia. I hope that everyone stays safe and healthy during this pandemic. First, I would like to thank Dr. Harald Sippel and the Bali International Arbitration and Mediation Center for their crucial role in making this webinar happen. Second, I would also like to thank and welcome the students and international law societies of Universitas Gadjah Mada, Universitas Airlangga, Universitas Pajajaran, Universitas Katolik Parahyangan, and Universitas Prasetya Mulia for their partnership with us. The International Law Moot Court Society is excited to have you all here today with us, and I hope we can have a fruitful discussion today. Justin, I'll give the floor back to you.
Yes, thank you, Fadira, for your opening remarks. As I'm sure the participants are already eager to start the discussion, we welcome the moderator today, Heru. The floor is yours.
Thank you so much, Justin. Good afternoon, everyone. I hope you're doing well this situation. My name is Heru Anashahdio, and I will be your moderator for today. And first and foremost, I would like to thank Harald as our guest speaker for today. I am honored that you were able to fit this webinar within your busy schedule. I, as a final year of law student, am sure that along with the enthusiastic audiences here, we'll learn a lot from you with regards to building a career in alternative dispute resolutions. Secondly, I think I would also convey my appreciation towards ALMS and BIAMC, especially for the committee involved in conducting this extraordinary webinar. I think little opening remarks from me is that, in my experience as this year's Faculty of Law most outstanding student and have been competing in FIS commercial arbitration, I realized that a lot of people are still unaware about the professionals working in the alternative dispute resolutions industry. When I was discussing my future with my colleagues or even my lecturers, and I said that I want to pursue a career in ADR, their first response will always be, so you want to be a judge? Then I will spend time explaining about ADR to them and hoping that they would get it. Hence, I hope that today's session could be the basis for a lot of people to understand the professionals working behind the ADR industry and even get more people to pursue their career in alternative dispute resolutions. Now, before I let Harald to share his wisdom with us, I think I would like to run a few details on how we're going to conduct the session. So we'll start with a presentation from Harald, where over the course of this presentation, we want the audience to engage with us. That is why Harald has prepared several poll questions for the audience to answer, and we will discuss those responses together. And with the spirit of engaging with the audience, we will also open a Q&A session for the audience who wants to ask Harald the question with regard to the materials that he will be conveying. You can utilize the Q&A box, and I will consider which one of the questions will be appropriate to be conveyed to Harald for him to answer. And I think the audience is very excited now to hear the presentation coming from Dr. Harald. So I think I will give it to Harald, if you may.
Thank you very much, Heru, Justin, Fadira, and everyone else who's involved. There's a lot of people to thank for. Also, I want to thank every single one who is joining in today. It's Saturday afternoon, so selamat siang. I think a lot of people have something better to do, whether there is some sort of lockdown or not. So I'm pleased you are here, that many are joining us, that so many are joining us, I should say. It puts the pressure on me to meet the expectations, and I'll do my very best. I want to echo what Heru said in the introduction. A lot of people have a lot of misunderstanding about what working in ADR, and even if it's just arbitration as one form, is, what it entails, what it means like. And we will do a lot of demystifying today. My goal is that by the end of the session, you will have a clear understanding, at least in the basics. Keep in mind that this is just a 2-hour session, but you will have a clear understanding of what options you have, and also importantly, what you should do in order to actually be able to enter this field. Now, I'll be sharing my screen, and then we can start. Now, what we are going to cover today is an overview on ADR and the different roles in arbitration in particular. Now, ADR is usually, well, it means alternative dispute resolution. Some people include arbitration, some people do not include arbitration. It doesn't matter for today's seminar because for the most part, I'll only speak about arbitration because this is by far the most common form of dispute resolution other than court. We will touch upon what you do, how you can build your career, and what qualities are needed. This is just a final part for you in international arbitration. I'm here referring to graduates who want to join law firms for the avoidance of doubt. I think there is no point in me telling you what makes a good arbitrator, and then tell you, if you are lucky, then the first time you will act as an arbitrator is 7 to 10 years after graduation. I want what I'm teaching you to be applicable right away. And I want you to be able to take what I speak about today and put it into action immediately. As Harald said, and I want to remind you one more time, if you have any question, please do ask it in the chat function. Harald serves as a filter, so feel free to ask any question at any time, but Harald will decide whether he will pass the question to me right away because it fits the topic. If he doesn't do so right away, it doesn't mean that we will ignore your question. Please don't misunderstand this. Harald knows more or less the course of my presentation, and he is much better suited to decide when to ask the question. So, you know, my reminder to you, or my request to you, do ask questions when you have any concern or whatever is on your mind. To make this more interactive, because I don't want you to fall asleep behind your computer screens, we also have several poll questions, and I'm looking forward to seeing the answer on those. Now, let's start without any further ado. To make sure we are all on the same page, I want to briefly touch upon ADR, Alternative Dispute Resolution. And to that end, I want to show you how you can generally resolve disputes. I'm starting on the left with the most peaceful form, so to say. Now, when I say peaceful, it doesn't mean that litigation or arbitration is violent, but peaceful means it's entirely the parties who do it among themselves, and typically this is at the very early stages of a dispute, or maybe it's not even a dispute at this point. It can just be a different understanding of certain facts. It hasn't necessarily become a dispute yet. So this is on the left side, and the more adversarial it gets, the more parties fight, the further we will go to the right. Now, negotiation simply means that the parties are discussing among themselves. It's an informal process. Nothing particular to mention. There is no third party involved, typically. We then have mediation. Mediation is a process where you have one person, usually one person. Here on the picture, it's the green person, not from Mars, but the green person being the mediator. And you have the blue party, so to say, and the yellow party. It doesn't necessarily have to be just one person. There can several people. And the mediator tries to, or helps the party in reaching a settlement. This is a process which is also very informal, in the sense that there are very few rules involved compared to other processes. I don't know if any of you has taken civil procedure law, but when you think of the Code of Civil Procedure, it's, you know, these many rules. For mediation, there is almost no one. The parties can pretty much decide how things go. What's important is that typically the mediator will only assist the parties in finding a solution to their dispute, and will usually not propose the solution itself. However, the borders are not clear, and conciliation is another form where, in this case, the red person, it's not a green person anymore, would make actual suggestions on how the dispute can be resolved. I think you can, what you can see from those pictures, and for you to remember the difference between mediation and arbitration. And as I said, the borders are not entirely clear, but for you to remember, when you look at the mediator, that person is doing like this. I'm leaving it to you. However, when you look at the conciliator on the picture, that person seems to be sort of pushing the parties to something. And I intentionally chose those pictures because it very well shows that there is a difference, that namely the conciliator will typically make specific suggestions as to how the dispute could be settled. We then have another form called expert determination. This is particularly for technical issues, but also for financial matters, where the legal consequences are quite clear or simple, but the question is on the facts. For instance, think of an agreement between two parties where company A sells a part of its company to company B. And the agreement contains a bonus clause saying if the sold part of this company has a profit higher than X, then the buyer must pay a bonus, something like this. You don't need any judge or arbitrator, or in particular a lawyer, to determine what the actual profits were. And it may sound obvious to you, but profits are not always obvious. It's a whole science of its own. And generally financial data, I should say, is not always so clear and straightforward. On technical issues, you could have a case where there is a warranty claim, and the consequences of the warranty are entirely clear, but the expert, an engineer, has to determine if a party, the party which bought the technical product, used it the wrong way, or if the product was defect, for instance. So here, again, you don't need, whether you use it the wrong way or it had a defect from the beginning. That's not a question of law, that's a question of facts. So you would use an expert determiner for this. You have adjudication, which I'll only touch upon very briefly because in Indonesia, it doesn't exist in a statutory way. It's usually used for construction disputes, and they are usually for payment claims. That's all I'm telling you now. You have arbitration. I will not say much more on arbitration at this point because we'll get to arbitration in a minute. And the most adversarial process, where usually you have most friction, is litigation. Although arbitration and litigation are in many ways quite similar. Now, you may notice that there are two more black bars here, one on the very left, one on the far right. This is because there are actually two additional options I wish to highlight. And when I say two additional, please keep in mind that this is not everything which exists. These are the most common forms, but it's not that there is nothing else. You can also agree on a mix, for instance. You could say that when there is a dispute, the parties should first negotiate, then they should mediate, and then they should arbitrate, or something else. But as I said, there are two more bars. On the far left, it is flight. You can simply run away, so to say, decide not to do anything. And on the far right, you can fight. Both are usually not recommended ways. Especially, don't think of fighting as in a fist fight, but because we're speaking about business disputes here, and companies themselves cannot engage in fist fights, only their employees or representatives, and that doesn't happen often. But when I speak of fight, sometimes there are means to force a company to pay something which are illegal. Think of mafia methods of loan sharks, etc. This doesn't happen often, so I'll not go into detail. For the flight, it's always up to you to start the dispute or not. By starting the dispute, I mean to actually start the formal process. When you lend someone money and that person does not repay, you can decide to go to court, or you can decide not to do anything. That's entirely up to you. So when you don't do anything, that's flight, so to say. Sometimes not doing anything is the best decision because you know, for instance, that the company which owes you money is on the verge of bankruptcy. You know, what's worth the effort and the money of starting proceedings when you know they will go bankrupt anyways? So this would be flight. Having said this, we come to the first poll question, which is which of the below processes you just saw do you think is the most common process for the resolution of business disputes? And I'll remind you of the options we have once again. And I now kindly request all participants to select their answer. And I don't know, Harald, are you going to convey the results, or how is it going to work?
Yes, Harald, so the committee will launch the poll to the audience. However, I will be the one that shared the results to you after they have answered the poll. Okay,
so we probably wait for one minute or so. Maybe I use this time to again highlight one other way for a flight. You know, by flight, and I'm going back on my slides. Flight, as I said, is not running away, as in, you know, you leave the country and you go undercover and you probably do plastic surgery so that no one can find you. It usually means you don't do anything, even though someone should pay you money, or you are entitled to something, but you decide not to use that right. Think of a situation also where you want to maintain the relationship with that company. Think of a situation where you absolutely rely on I don't know, a supplier of your products because there is no one else. This could be, for instance, because it's rare earth. You may have heard of this term. There are some minerals, for instance, or I don't know what exactly it is, some metals, I think I should say, which can almost exclusively be found in China by way of mining. Now, if you absolutely need those and you only have one supplier, then you know, you may not want to start a fight and may just let go with it. Okay, and Harald, you are sharing the results with me. Do you want to present it?
Yes, Harald, thank you. I think it's interesting that majority of the audiences thinks that negotiation is the most common form of resolution of business disputes. And I think it will be followed by mediation and arbitration having the same amount of votes, and conciliation being the least answered by the audience. What do you think, Harald, about this result?
I think this result confirms that the average is always right. Negotiation is the most common form because the vast majority of disputes never go to court, never go to arbitration, never go to mediation or anything else. The vast majority of disputes are resolved by mutual discussion. Now, I have the second question right away, and leaving negotiation aside, please ignore negotiation now. Which one do you think is the most common process for the resolution of international business disputes? I put negotiation there, but please ignore it. That's actually my typo on the slide. Please do not select negotiation. What is an international dispute? Maybe for you to understand, it's very simple. The definition would usually be one party is from country A, one party is from country B. So let's take the viewers today. You are Indonesian and I am Austrian. Let's say you have a company and let's say I have a company, and both companies have a dispute. Since you are from Indonesia, which is country A, and I'm from Austria, which is country B, that's an international business dispute. Some people would also include a dispute, or would include in this definition disputes where the subject matter is international. Let's say an Indonesian company sells a factory in Thailand to another Indonesian company. Now, both companies are Indonesian, but obviously the subject matter is in Thailand, so that's international. So once again, I'd ask you to make your vote, and please do not select negotiation, because that's my typo on the slide. And Harald, whenever you're ready, please to share the results. We'll probably wait for a few more seconds.
Yes, Harald, I think we should wait as the audience is still voting here. I see that arbitration is getting a lot of polls now.
Don't influence anyone though, please. They will go with the majority.
Okay, we'll see. All right, I think.
By the way, if anyone is worrying, we are not going to report how you vote back to your professors, so no one is getting into trouble.
All right, I think we have the result here, Harald. And again, I think 63% of the audiences thinks that arbitration is the most common form for international business dispute, and it is followed by mediation, and I think litigation is one of the most bold answer. What do you think on that?
Right. Thank you, Harald. The average, or this one, it was the majority, is again right. Very good. According to surveys, companies most commonly use arbitration. The second form is actually not mediation or litigation or anything else that's directly on the slide. It's a combination of any less adversarial process and arbitration. So most typically mediation and arbitration combined. So great. Thank you very much, everyone, for for sharing your thoughts. It's great to see that so many people voted, and I'm also particularly happy that a lot of people got it right. Those who didn't get it right, please do not see this as something negative. This is just a survey, what you think, and now you know that it's arbitration, and if there is ever anyone else asking you that question, or maybe your professor, then you will get it right. Now that you understand sort of what types exist, let's look into arbitration as such. And I'm giving you a very basic overview because I want to make sure that we are all on the same page. I understand from the team setting up this talk, this webinar, that there are also quite a number of freshmen with us. So it will be at a very basic level, but I'm still covering all important points. So don't worry about this. What you've probably all heard about is the arbitral tribunal. This is most typically one person, a sole arbitrator, or three people, the two co-arbitrators or wing arbitrators or party-appointed arbitrators, and the chairperson. Now, the chairperson may also have different names. It simply depends on the law or on the rules. The chairperson may be called presiding arbitrator. The chairperson may be called president. At the end of the day, how you call it really does not matter. It only matters that there is someone who is a chairperson. You then have the parties, the claimant and respondent. That's how we call them. I put them in different colors here. The claimant is red and the respondent is green. This is just how I do it. There is, that's entirely my choice because I want you to be able to differentiate. The way I put this on the screen is also how in a hearing, the parties would usually be seated. You have one party on one side and one party on the other side. Now, there are different ways to do this. Some people believe the claimant should be to the left. Some people believe the claimant should be to the right. It really doesn't matter. What matters is what you say during the hearing and not how you sit during the hearing. So just because you sit on the left side instead of the right side doesn't mean anything. I've been involved in arbitrations where I was sitting as claimant on the left side as well as on the right side, and the same for respondent. It really doesn't matter. You sometimes have a tribunal secretary. Now, this person is in blue as the arbitral tribunal because this person supports the arbitral tribunal by usually fulfilling administrative tasks. I will explain a bit later who that usually is and what those tasks are. You then typically have witnesses. They can be witnesses of fact or expert witnesses. Expert witnesses, I'll also discuss in a minute who this is. Witnesses of facts, from civil procedure, are those who describe certain facts, their own observations, etc. In an international arbitration, you often have an interpreter who would be sitting right next to the witness. Now, it's probably not entirely clear on your screen, but the color I chose for the witness is a mixture of green and red. This is because you can have witnesses who are presented by the claimant and witnesses who are presented by the respondent. Both are possible. And for the avoidance of doubt, the interpreter may be sitting, as I did it on the screen, closer to the claimant or closer to the respondent. That's really, again, it doesn't matter. The same goes for the tribunal secretary. You could put the tribunal secretary to the right. Also, none of this matters. I just had to put it somewhere on the screen, and that's why it is where it is. You then often have a court reporter, as we call it. Now, don't get confused by the name court. This says it's still an arbitration. A court reporter is simply a person who transcribes what is being said. There are at large two types of court reporting. One is live transcripts or simultaneous transcripts, and the other one is transcripts after the hearing. So in a live transcript arbitration, the court reporter will type everything as everyone speaks. They don't have regular computers, they have a special device, and it's actually a very difficult job. And then each party has one or more screens on the desks before them where they can see everything as it's spoken. This is extremely useful because it allows you to go back a few lines if you want to double check. I can also tell you from my own experience that it's extremely useful when you're dealing with someone whose command of English is not the best. I was once involved in an arbitration where the other side was from Italy, and they spoke like this. It was very difficult to follow. I had a very hard time. So it was very useful for me to have the screen, and even more so for my colleague sitting next to me who did not know any Italian. So these are the two types. There are additional, or wait, let me tell you how it works. So usually you would start an arbitration because the claimant, and I'm now getting to additional actors in arbitration. The claimant files the request for arbitration with an arbitral institution. So this is typically how an arbitration is started. In some countries, the claimant can file the request for arbitration directly with the respondent, but the more common way is that you file it with the arbitral institution. So when we go here, we had those different actors you see on the screen. You now have one more, the arbitral institution. The arbitral institution would then forward the request for arbitration to the respondent. And ultimately, the respondent and the claimant together appoint the arbitral tribunal. This is in a really compromised way, the course of an arbitration and how it starts. And this is how it would go. So the moment the institution hands over to the arbitral tribunal is in charge of the arbitration. Now, who are the people acting? For the claimant, we usually have lawyers. Usually the claimant will be represented, and usually by a law firm. So there is nothing special about it. It's simply lawyers who are acting. In an arbitral institution, you have so-called case counsel. These are also almost always persons with a legal education. They may be admitted to the bar or may not. It really depends on the jurisdiction we are in. Keep in mind that in some jurisdictions, it is quite difficult to become admitted to the bar. For instance, in Austria, you can only get admitted after you pass the bar and can show work experience of 5 years. Before that, you are not admitted, although you do regularly go to court, but you always act on behalf of your master, so to say, of the lawyer training you. You cannot call yourself lawyer. You can call yourself, I don't know, associate lawyer or something like this. So in a jurisdiction like Austria, where it's quite difficult to become a lawyer, those who are working with an arbitral institution are often not allowed to practice, but it doesn't mean that they are, less qualified in any way. The respondent, it's the same for the claimant. We also have lawyers acting there. There is nothing special about it because the representative will be a law firm. Maybe one note on this, and that's a huge differentiation to court. It is not necessary in arbitration that you are represented by anyone. You can do it on your own. And you can, in principle, choose whoever you want to choose to represent you. Above all, you don't need someone who is admitted to practice in your country. So when you have a let's stick to the example I gave, the dispute between two Indonesian companies over the factory in Thailand. It would be absolutely okay to appoint someone from Indonesia. It would be absolutely okay to appoint someone from Thailand or from a third country. It's entirely up to the parties. For the tribunal, you usually have lawyers acting. So those are lawyers in law firm. They act as lawyers, sometimes as counsel, so to say, as party representatives. Sometimes they act as arbitrators. You have what I here call professional arbitrators. And by that, I do not mean that those who are not professional arbitrators are unprofessional arbitrators. This is to say that those are people who earn their money entirely by acting as an arbitrator. So you don't act as a party representative, you only act as an arbitrator. And there are others, because sometimes it is much, much less common, but sometimes you have academics, law professors who act as arbitrators. You have people from the financial industry, or you have people with a technical background. Again, it's much less common, but it does happen. With that, let me briefly highlight the other actors I've already introduced. We mentioned the tribunal secretary. This is usually a lawyer in the chairperson's firm. It's not necessary. The tribunal can, in principle, appoint anyone they want to. But when you are asking people who act or acted as tribunal secretaries, the vast majority will tell you that they are working for the same law firm as the chairperson. I have myself, for about 1.5 years, worked in a law firm where the where my boss, I should say, was almost exclusively a professional arbitrator. Like 98% of the work was work where he sat as an arbitrator, and I very often acted as tribunal secretary. Now, to maybe give you some background, because I think it's clear what a lawyer does. They represent the parties. The tribunal will hear the case and then decide. They render an award. But what does the tribunal secretary do? The tribunal secretary should never be a fourth arbitrator. It's someone who assists the tribunal and supports it, but the tribunal secretary should never share his or her views on the case, because this is entirely for the tribunal. Now, what does that person do? I can tell you what I did. What I did was, I would typically make summaries of arguments made by each side. So I would prepare tables of the summaries. I would also make summaries of legal positions, etc. I would be in charge of liaising with the parties when it came to purely administrative matters. For instance, what is a suitable location for the hearing? Where should the hearing take place? Should it be in a hotel? Should it be in a professional hearing center, etc.? Those issues. I would often liaise with the arbitral institution. For instance, when there was a new claim, I would make sure that the institution was aware that the amount in dispute has changed. That's always important for arbitrators, because that usually means more money. So if you want to make your boss happy, you can tell your boss, oh, by the way, I've already made it clear that they updated the amount in dispute and they confirmed. So your boss is happy because he or she will get more money. So those are the functions. The tribunal secretary is usually also involved in the drafting of the award, but it should never be the dispositive part. Now, the dispositive part is the part where the actual decision is written. What the tribunal secretary will draft is the introductory part, the procedural history, the positions of each side, etc. All the parts which are undisputed. And it is undisputed that company A is called company A. It's undisputed that company A was represented by lawyer B. It's undisputed that on, 1st July, company A sent a letter. All those things are easy, so to say, but they must still be in an award. And just because it's easy in the sense that it's undisputed doesn't mean that it's not important. It's actually not so easy when you do it for the first time, when you have to draft the initial part for the first time. And the very good thing about working as a tribunal secretary is that in a short period of time, you see a lot of different cases, a lot of different arbitrations, because usually you can sit as an arbitrator, you can sit in many more cases than you can act in as a party representative. The requirement in terms of hours you spend is much less for an arbitrator than it is for a party representative. So this is why, as a tribunal secretary, you see a lot more. And what I truly enjoyed when I acted is I really learned a lot about the procedure, because to learn about procedure and well, I should say procedural problems, you have to be involved in many arbitrations. Usually, you don't get so many procedural problems in one and the same arbitration, but the more you see, the more problems you see. So this is why I like that. We have another poll, but I saw that there were some questions. I just want to confirm, Harald, do you want to ask me anything right away, or shall I move on?
Harald, I think there is some questions that you could ask within this part of your presentation. I believe that you have mentioned that in arbitration, the lawyer should not be coming from a certain area, and you can even be represented without a lawyer when you are arguing your case in front of an arbitration. So we have a question from Amrul, which he asked, do lawyers in arbitration should be registered to a certain bar association? I'm sorry, Harald, I think you're still on mute.
Sorry, thank you. As I said, it's no. Anyone can be a party representative in arbitration. There are some strange jurisdictions, I should say, not strange, but highly unusual, where this rule does not apply. For instance, in the Philippines, you have to be, as a party representative, you have to be admitted to the bar in the Philippines. I know of instances in Indonesia where Indonesian counsel objected to a foreign lawyer acting in an arbitration on the basis that the foreign lawyer allegedly needed a work permit and had no work permit. But this is not the arbitration framework. That's a different framework. So you know, it's if I were a lawyer in that situation, I think I would have said, well, okay, screw you, I'm still going to do this because this is my client and I will fight for my client. And you can report me to the authorities because, by the way, by the time they start taking action, I have left the country. So again, usually you do not need to be admitted to any bar. It's entirely up to the parties who they want to appoint. In fact, I was involved in 2 arbitrations as an arbitrator, where in each case, one party was not represented. They simply did it on their own. It wasn't good. This is because when you don't know the law, it's very hard to make proper legal arguments. And in both instances, these parties lost, ultimately. They didn't lose because I disliked the fact that they were not represented, of course. They just lost on the law. And I think in one case, had this party been represented, I think they could have won the case. But as an arbitrator, you cannot decide on what you deem just and fair. You decide on the evidence you have before you. And if the evidence shows that party A shall prevail, then you must decide for party A, even if you think that, in fact, party B could, with the right lawyer, you know, show better, show much better its position.
Mm-hmm. And I think in that spirit, Harald, we do have another question with relation to representative in arbitration. So we have Muhammad Faki here. where
Okay.
he asked whether, in your opinion, is it best to have a lawyer to represent you in an arbitration proceedings, or it's actually fine if you represent yourself there? And I think you have mentioned a little
Right.
quiet, and I think you can elaborate further.
Unless you are an expert, I mean, you have a lot of experience in arbitration, you should not represent. By the way, that also goes to all those lawyers who do a lot of litigation. Please do not think that you can do arbitration just because you are a litigation lawyer. I've seen the most absurd instances, including one case where I had to explain to the other members of the arbitral tribunal about basics of arbitration because they simply didn't know, because those were litigation lawyers. Now, I want to go back to this part on the right here on the screen, the tribunal. I mentioned that tribunals, like those who act as arbitrators, they often take on different roles. And we have another question here for you. Do you think this is appropriate if someone sits as an arbitrator in one case and as a counsel in another case? It's obviously not the same case. We're speaking of different arbitrations. But this double hatting, as it's called, the hat of the lawyer and the hat of the arbitrator, what do you think about this? And whoever is running the poll, I think you need to change that question. If there is a technical issue, please let me know and I'll just move on.
Hang on, Harald. I think we're going to ask the committee to change the poll question. All right.
Maybe to give you a bit the background, why do people do this double hatting in the first place? It's because it's quite difficult to make your living as an arbitrator. Now, those who do make a living, don't get me wrong, they usually earn quite a handsome amount of money, but it requires that you get appointed very frequently or that you get appointed in very big disputes. Usually the fees you earn as an arbitrator depend on the amount in dispute. Some institutions base it not on the amount in dispute, but on the actual time you spend. But the more common way to do it is the amount in dispute. Now, as a lawyer in a law firm, when you are a partner, keep in mind that you get your own hourly rate, so to say. So when you work, that's how you can generate income. And of course, you have a team below you, and the rate you charge to the client is, of course, much higher than what you pay to the people below you. So in a, as a lawyer, when you also do representations, it's much easier to generate income. This is why a lot of people do double hatting, but also some simply enjoy it. So I don't know where we stand. Heather, whenever you are ready to present the results.
Yes, we are ready now, Harald. I think to the question of, do you think it is appropriate if someone sits as an arbitrator in one case and a counsel in another case, 82% of our audience thinks that it is appropriate, while 18% of them think that it is not appropriate.
Okay, thank you. There is no right or wrong answer. It's a personal question. But what I can tell you is that there are a lot of conflicts of interest in international arbitration because this happens. As a judge, you can, in most jurisdictions, only act as a judge precisely for that reason. But again, the difference is that as a judge, you will get your salary anyways. You don't have to worry about finding a new client, etc. So we were just interested what you think. Again, there is no right or wrong. I'll move on and present you one more actor in an arbitration. It's in-house counsel. Now, who is an in-house counsel? It's a lawyer who works for the claimant or for the respondent. Again, you can see the color here is green and red combined. This is because both claimants and respondents can have in-house counsel. Not all companies have those, of course, but the larger ones all do. Some very few selected companies have highly specialized teams, dispute teams. I think the best known company is Siemens, and another company which is quite famous for its in-house team is Bombardier. Those are two very notable examples. And when you speak at international arbitration conferences, you often have people from these companies who speak as well. Now, when you act as an in-house counsel, when you work as an in-house counsel, I should say, it has several ups and downs. The biggest up, I believe, is that you see everything from a party's perspective. A lot of lawyers do not understand how the actual parties in disputes think, and they really get this wrong. So this is a huge advantage. Another huge advantage, some people say, is that you see a whole spectrum of fields you work in. You would never, or almost never, just work in the field of arbitration. You would usually do a whole series of different fields. Other people say that this is a disadvantage. Those people say you have to specialize these days. And if you are not specialized, then you know a little bit, or you could say you know almost nothing about everything, which is not good, because if you know almost nothing about everything, it's not a lot. Of course, it depends. If you know just a little tiny bit, but you know about everything, you will be much better off than someone who knows exactly nothing. So it really depends. In-house counsel are usually involved in arbitrations in the sense that they coordinate the lawyers representing them. You would report to them, you would give them regular updates, and they then internally have to report themselves to the management or to the general counsel. They sometimes act themselves in international arbitrations when they don't rely on external lawyers. This would typically be the case when the amount in dispute is very small, but it depends. I mentioned experts, and I mentioned the fields they act in. Here again, I highlighted the legal experts because you are all law students or possibly graduates. So you can become a legal expert if you wait for 30 or 40 years. No, it's not that long, but it's usually very, very senior people of a country. So you have to be a very senior, typically academic. Then you will provide your expert opinion on a particular legal issue. Now, those are the actors in arbitration. And we have another question. Now that you've heard what different possibilities exist, which one do you find most appealing based on what you know? And we kindly ask you once again to share your views. Again, I want to highlight, and please cast your vote while I'm speaking, there is no right or wrong. What you find appealing is entirely your opinion. What I've been trying here is to present you in a nutshell, really, some of the roles which exist so that you know the basics. I think each role has its advantages and disadvantages.
And Harald, I think while the audiences are answering the poll, I do have some question with regards,
Sure.
With regards to your explanation on the experts. So, you know, when I was doing FIS last year, I think one of the biggest issue that we've encountered, that our team encountered, was that independent of the expert itself, you know, a lot of journals told us that it is actually acceptable for some experts to give a more preferable expert testimony towards one party that hires them compared to the other party. So what do you think? Should expert be, should expert have the same standard of independence like arbitral tribunal, or do you think it's actually fine if some experts give opinion that is, more favorable towards the party that hires them?
It's an excellent question, because it's an issue that not only arises in the Wismut or arose in the Wismut, it also arises sometimes in practice, although not that often. There is the legal side and there is the practical side. The legal side is that the expert owes a duty of impartiality and independence above all to the tribunal. It's something the expert owes. So in theory, the expert cannot issue an opinion that is favorable to one party just because that party hired that expert. So if the expert determines that party A was at fault, just because party B hired that expert, then in principle that's not okay. Experts, of course, and that's the practical side, know who hires them, and they want to get paid at the end of the day. So every expert will try to issue an opinion, an expert opinion, which favors the party which hired that expert to the extent that is possible. So when I say to the extent that is possible, when we speak about who is at fault for the technical problems, to really simplify it here, the expert would never write, there cannot be any doubt that, when in fact there can be doubts. But the expert would write, based on the evidence before me, I come to the conclusion that it is more likely that, something like this. This is really, really simplified, because it's difficult to summarize it. But the expert at the end of the day needs to get paid, and you get paid to issue an expert opinion. And if that expert opinion is against the party that hires you, arguably you are not even fully entitled to your fees. It depends on the agreement you make, but it's a complicated matter. And I see we have the poll results.
Yes, we do, Harald. And I think the most popular career path being chosen by the audiences are counsel, followed by institutions and tribunal secretary, and as well as in-house counsel. And I think 5% of them interested in the academic career path.
Okay, that's great, because I will briefly speak about all roles, at least to some extent. Maybe the one I speak about least is academic, because this is something which would largely depend on the university which hires you. And there are really huge differences. For instance, in the Netherlands, it's very easy to be called professor. In other countries, you remain a lecturer for many, many years, even though you have tons of experience. But it's great to see that there is diversity. Now, this brings me to the second part. Irrespective of what type of career you want to pursue, how can you build your career in arbitration? And we have another poll to keep everyone awake. In addition to getting good grades, is there anything you believe you can do as a student, and that includes freshmen, to advance your career in international arbitration? This is a fairly simple question because it's a yes/no question, so I'd be very grateful if you all answer as soon as possible. Again, there is no right or wrong because it's something you think. I will tell you in a minute what I believe. And maybe while you vote, I will tell you how I got where I am today, especially about my times as a student and what what I did as a student. I originally never wanted to become a lawyer. When I went to law school, I wanted to become a diplomat. This is why I went to law school. I then got to know a lot of different diplomats because I attended every single event I could, and I simply approached those people, which was quite daring, but everyone was happy to speak to me for a few minutes. I realized after speaking to several ambassadors and learning about their roles that this was too boring for me. Boring in the sense, please don't get me wrong, I don't mean to look down on or give the impression that I'm looking down. Boring in the sense that as a diplomat, your actions are typically more reactive than proactive. And this is what I didn't like. I then chose that I wanted still not to become a lawyer, but wanted to work in business. And I was looking for a topic for my thesis. In Austria, when you want to graduate from law school, or at least back then, times have changed now. Back then, you needed to write a thesis. And I was looking for a thesis which was as, okay, and I can just announce this. Everyone thinks that you can do a lot as a student. So this is great. I think this is why you're all here. So I think we can simply move on like this. In the interest of time, I wanted to work in business, and I was looking for a topic which is as closely as possible related to business as opposed to just law. So I chose to write about international arbitration in East Asia. This was my, so to say, way to enter the world of international arbitration for the first time. I never took part in any moot court competition. I must admit that when I was a student at law school, I didn't even know that moot court competitions exist. I'll openly admit that, which is quite funny because I ended up writing a book on moot court competitions. So you would assume that I had participated in a dozen competitions, but it's not the case. I then, after graduating from law school, took an MBA degree, and because I wanted to work in business, I wanted to become an investment banker while I was doing my MBA, but I ended up being hired by one of my professors from the MBA, who was also a lawyer, and back then a partner at a Chinese law firm. So I became I think it was called foreign legal consultant in a Chinese law firm. That was my first proper job in the field of law. And there I did arbitration, and I realized that I loved it. And this was my entrance to the world of arbitration. Now, every story is different. And this is just how I did it. And I later on did several other things in addition to writing a thesis on arbitration. But this is just my way. There are numerous other ways. So I'll highlight now what you can do. The principle is that you must show your prospective employer that you are better suited than others. It's as simple as this. But how can you be better suited? Above all, from my experience, you need to show that you know about arbitration and that you are very interested in arbitration. Now, I can tell you from interviewing applicants that everyone is going to tell employers, I'm so passionate about arbitration, which, you know, is great, okay, but as an employer, I don't care whether you're passionate or not. I want to know how much you know and how much you've already done. How much you know you can only show me through something you have done or something you have achieved. If you say, I'm so interested, you know, this is entirely your perspective, but you should put yourself in the shoes of the employer you want to hire someone who you believe you have to train much less because that person already knows a lot more. So you can only show that if you have already done something or achieved something. So what can you do? Specifically, you can participate in a moot court competition. I don't mean to go beyond that. I will not explain what a moot court competition is. I think most of you know about it. If not, find out from ILMS. After all, they are the experts here. I can tell you very specifically how this matters. And I did about 5 minutes of research yesterday night when I was making my slides. This is in German. I'm sorry about that, but this is the extract of a job advertisement of the law firm CMS, which is one of the largest firms in Germany. And the part at the bottom here says that one of the assets is prior knowledge in arbitration, experience in moot court competitions. So I think in Indonesia, it's not entirely the case yet, although I'm sure employers will appreciate it. In Europe, it's considered a huge plus if you have done a moot court competition. I found another job advertisement from the Max Planck Institute for Comparative Public Law. This is also from Germany. It's a coincidence. Those were the most recent job adverts I found, both of them from July. Here, they are looking for a coach for the chess of moot court. And, excuse me, this coach, for the avoidance of doubt, would be employed. It's not someone who would be a volunteer. You would be employed and actually get a salary. And the requirements for the position are, among others, successful former participation in a moot court competition. So you can see here clearly that participating in a moot court competition is a huge advantage. And again, these are just 2 job adverts I found from July. Had I taken more than 5 minutes, I'm sure I could have found at least 5 more job adverts. When you participate in a moot court competition, you learn a lot about at least a portion of arbitration, and it's a great way to show to your prospective employer that you are not only, passionate about arbitration, but that you actually followed your passion and did something about it. Mm. If you win awards or even come first, like Harald did, of course, that's awesome, but I don't think it's necessary. The moment you can show that you were really interested and did something about it, it's sufficient. Mm. Anything you want to add, Harald, or should I move on?
Yes, Harald, maybe just a little bit. So I think what the point that you were trying to convey is at least the participant or the student did something concrete with regards to their passion in alternative dispute resolutions or arbitration, rather than just saying that they are passionate with it, right? Yeah.
Yes, yes. When you say I am passionate, you are only speaking from your perspective. You don't show the employer what asset you are. Of course, I would prefer working with someone who has more energy than someone who is, a very boring person. So being passionate as such is good, but excuse me, it's still entirely my perspective of the world, and it should always be from the eyes of the employer. So this is why I say do something concrete and don't simply say, oh, I love this so much. Right. Do something concrete in the sense that show you participate in a moot court competition, or participate in an essay competition, which is the second point I'm making. By the way, these are not in order of importance. All of these are useful, relevant. I again did a few minutes of research. There is now a writing competition by the young SIAC, and you can still participate because they just extended the time limit. The concept here, this year, is quite interesting. You have to prepare a written brief to a tribunal in a mock arbitration. So this is actually quite arbitration related, and not simply, you know, just you write about any topic. It's very much to the point of arbitration and practice. And the good thing is, in these writing competitions, you can even win prizes. So there is no reason to not participate if you think you are qualified. And excuse me, even when you think you are not qualified, it's a good training exercise. You can, that's my next advice, publish. You can publish an article. Now, you probably think, I'm still a student, how can I possibly publish an article? Two comments on that. First, there are numerous student journals out there. Maybe, I don't know about Indonesia, but you find them, and many of them are in the field of ADR. If you take the time and to do research, and if you hone your writing skills, you can definitely publish something in a student journal. If you do a really good job, probably even in a in a professional journal. It doesn't necessarily have to be an article about something very specific about arbitration. You could, for instance, publish about events. You write an event report. This is, of course, a publication that counts less than a publication where you write about a specific topic, but it still counts. It's a publication. And who would you rather hire as an employer? Would you hire someone who says, I'm so passionate and I love this, but I cannot show what I did? Or someone who says, I'm so passionate, I love this, and this is why I publish 2 articles in my free time? I think the answer is obvious. So this is why publishing matters. It's just a way how you can show your future employer that you don't just say, I'm interested, but that you actually do something about it. By the way, what I'm mentioning here is the publications, is something I have been doing from the very early days of being a lawyer. I now have published about, I think it's almost 30 papers or book chapters and 1 book. And I'm currently the editor of a book where we have over 20 authors. So this is sort of the peak I've reached so far, that I'm now the editor, which is the pinnacle if you want to say so. But publications are a way to show to your employers not only that you're interested, not only when you're a student, but you can do that throughout your career. You can join young organizations. Now, what are those? I put 4 on the screens. I think those are the 4 best known. I put ICDR, Y&I. I put the IBA Young, I think it's called Young or IBA 40 Subcommittee on Dispute Resolution, the YSISE and ICC YAF. Some names sound likely familiar to you. The International Center for Dispute Resolution is the most prominent arbitral institution in North America. The IBA is the International Bar Association. The SIIC is the most prominent Singaporean institution, and the ICC is the most prominent international institution in the field of arbitration. You can simply look up those organizations and join and attend events. I think it's, just one more phrase, Harald, it's less important to join these organizations than it is to join to engage in those other activities. But when you join them and attend events, which is super easy now because it's all online and free of charge, you will learn a lot more about arbitration. And ideally, you can even get to know other people and network. With that,
Yes.
Harald, I think you had a comment.
Yeah, I think I would agree with you, Harold, that in this, in this situation, I think the access to get into and build network through that organization has become easier since everything is conducted online, right? And I think one of the point that I would also be interested is that since you're the academic director of the BIAMC, I think, as I understand that it has some student membership, I think, within the BIAMC, and I think do you think that I believe that it would be beneficial as well, right, for the audiences here if they're interested with it?
If you don't mind, I'll address that on, I think it's the next slide.
All right,
because I
great.
have a picture. Yeah, but thank you for
All
raising
right.
it. And
Yes.
you're right, the BMC has a student membership. And what's probably different I mean, you can always join these organizations, but they don't really give you any certification. When you join them, you cannot get certificates for doing this or that. So this is why BMC student membership is, at least to that extent, better in my view. But I have to be careful to not come across as someone who is selling this too much, because this should be an informative session after all. But I think you raise an important point, and I'll get to it in a minute. The last point I want to raise here is relationship building. By that, I mean what other people call networking. I put 2 books here on the screen, which are great books on relationship building. I call it relationship building because to me, networking is very shallow, whilst when you build relationships, it's not just at a superficial level, but it's just a different way to name it. I can tell you that the vast majority of the jobs I got, or the work as such I got, including my position as academic director at the BMC, I did not get because I applied to that job. I got it because I knew someone who knew someone, something like this. Now, don't get me wrong, I'm not speaking about your parents knowing someone. This also happens, but that's not what I mean. My point here is that you can specifically speak to speakers of events if you attend them in person, or if you attend them virtually. You can simply drop a short email to that speaker and highlight a point you found very useful. You may not always get an answer, but you may get an answer, and eventually you may form a relationship with that person. Whenever I'm publishing something and I rely on an article someone else has written, I will, at the end of my, when I'm done with my article, I will send a brief note to the person who wrote that paper, which I rely upon, and say, thank you, your article really helped me. This is really just small things, but the more you do those things, and also the more you help other people, the more people will eventually help you. You should never help other people because you think, oh, maybe one day they can help me too. That's not the right attitude. You should help people because it's a good thing. Whether you are religious or not religious, I believe in any religion, it will be positive if you help. But also outside of religion, helping is a good thing. So you should always try to help people, and eventually your relationships will grow and grow, become stronger and stronger. And do not think automatically that just because someone is a lot more senior than you are, that this person is not interested in you. Now, also do not make the mistake that that person is automatically going to be interested in you, because neither is the case. It really depends. But what Keith Ferrazzi, for instance, describes in the book Never Eat Alone is that he helped the CEO of a Fortune 500 company to find an internship for that CEO's son. And because of that, that CEO was tremendously grateful. He could have never approached that CEO ordinarily, but because he helped that person, he could. And as a student, you will probably find it hard to create internship positions for other students, but that's not the point here. The point here is that even when one person is that important and you are that important, so to say, there can still be ways how you can help someone. I once got a shout out, so to say, at an international conference by Lucy Reed, who is one of the best known female arbitrators in the world, because I helped her prepare something for her speech. There was a misunderstanding on her side and she didn't prepare it. So I simply prepared some simple documents for her speech. Yes, it took me a while to compile everything, but because I helped her back then, she was tremendously grateful. And she became my contact, if you want to say so. It's not that she now owes me anything, of course, but the point here is that you can always help other people with as tiny matters as there can be. And that's the attitude you should have. So do focus on relationship building, because it's arguably the best way that you can ultimately find a job. Go to events, speak to the speakers, speak to other people, you know, find out what's important to them, etc. Education is an important part, because when we speak about education, it's that you can show to your future employers that you have done something. If you have 10 certificates because of courses you took, then you have 10 more certificates than someone who didn't take any course. So I think the easiest way for you is to take specific classes at university, if your university offers them. I don't know if they do, but if they do, take them. You can tell your employer, I'm very interested in arbitration. This is why I took international law, why I took ADR, why I took the moot court competition, etc. So this is very easy for you to do, because it's free and it's very simple. You can take an LLM, and I understand that also from Indonesia, every year there are several dozen students who go abroad to take an LLM. Now, what are my views on this? My views are we have one more poll at this point. When I speak to people from India, my experience is that many think that you have to do an LLM in dispute resolution if you want to enter this field, that this is the way to do that. So, you know, by the way, we mean that's really absolutely necessary and the most important thing you can do. We again want to hear your views on that.
Yes, and I think, yeah, and I think it relates to some of the audience question earlier, Harald, that they were thinking whether it's better for them to take an LLM or to, you know, spend and invest their time getting more experiences at a law firm, or yeah, specifically on a law firm. I think we are waiting to hear your thoughts on that as well after this fall.
Yes, I don't want to speak about it right away, because then I will influence the answers.
Right.
And we want this to be as objective as possible. Yeah, no, I'll not say anything.
Yeah, let's just address that after the poll then.
But maybe to make it clear, you know, those programs are usually abroad. Okay, and we have the results. I see them on my screen right now. Harald, do you want to present it once again?
Well, yes, and I think the majority of the audience think that it is the way to advance our career in ADR, while the 27% thinks maybe there is other way. So what do you think, Harald?
Yes, I'll share my thoughts. So there are numerous advantages when you take an LLM, and I've highlighted 3. It's prestigious. You know, if you graduate from a very good university in the US or UK, that's where most programs are located, it has prestige. I understand that it has a lot of prestige in Indonesia in particular. You get experience abroad, which is very good if you want to do international arbitration. And you increase your network. Remember, I just spoke about relationship building, and also your horizon, because you get exposed to a new world, to a new culture. And this allows you to think more broadly, which is very helpful in arbitration. The disadvantages I see, and of course, this is just my opinion, are the high fees, the cost of living abroad on top of the fees, and the opportunity costs. By opportunity costs, I mean, what else could you have done during this 1 year? Usually when you do an LLM, you don't work. Someone who stays back home, so to say, and does the LLM will have 1 more year of additional work experience, 1 more year of practical experience. And also this is to be added to the fees. When you work for 1 year, then you get paid for 1 year. And especially if this is right after graduation and you still stay with your parents, you know, your cost of livings are likely going to be almost 0 in Indonesia. And on top of that, you get a salary. So the difference money-wise can be huge. Now, when you get a scholarship or when your parents can pay for it, this is of course different. But I'm pretty sure that not everyone can get a scholarship or has parents who can afford it. So this is something you always have to keep in mind. Now, all the advantages are true and all the disadvantages are true. It's, again, there is no right or wrong. It really depends. It's ultimately your decision. And you have to decide what is better and more suited for you.
Mm-hmm.
I can tell you this much. I did not take an LLM, and for me, it has not been any problem at all. But of course, I did a lot of other things.
Mm-hmm. Yeah, Harald, I think, you know, as a final year as I'm in final year in my law studies, I think this topic interests me so much. And I think you could give us another point of view within the, you know, practical field of arbitration. Does the LLM degree really gives you any benefits with regards to your reputation, or maybe yeah, I think with regards to our reputation, would the LLM degree gives us a certain, you know, points in the arbitration sector? What do you think?
Mm-hmm. That's a very good question. I think definitely certain points when you try to get a job, at least initially for the first few years, yes. Although, and to answer a question you raised before, my personal view is that you should not take an LLM right after graduation. It's better to get some work experience, because what you then learn will be much richer to you. You can understand it much better if you have practiced law for a few years. After a few years, I don't think it gives you any advantage whatsoever when it comes to reputation. The advantage it can give you, somehow related to arbitration, is the network you have, the alumni network. If you are an alumna or an alumnus of you know, whatever university, and you can tap into the alumni network of XY university, of course it's a huge advantage. Because, but this goes back to the network as such. Mm-hmm. At the same time, you must keep in mind that it's a very expensive way to expand your network, because right. Just not having any salary for a year, this itself is very expensive. And one last phrase, Harald. Degrees as such, or titles, which really help reputation-wise, from my experience, are only a doctorate degree or ideally a professorship. People respect you much, much more when you hold a doctorate degree, or in particular when you hold a professorship. For the rest, it's all nice to have, but does it really give you a lot more reputation? No, I don't think so. Not from my experience.
Right. I think what we can emphasize here with regards to reputation and arbitration is that how we can increase our networking rather than the LLM title itself, right, Harald? I think if you can build your networking through working in law firms rather than taking an LLM, it would be more beneficial, you know, per se, rather than taking the LLM. But if you feel like taking an LLM will definitely increase your network and build your reputation in arbitration, I think it would be one of the viable options for them.
Yes, absolutely. Again, I want to make sure this does not come across the wrong way. I'm not saying do not take an LLM. All I'm saying is consider it very carefully, because the disadvantages you see on the screen, they are quite huge. And you know, it's the same for MBA degrees, of course. When you look at the most prestigious MBA programs in the world, they usually are not worth the money when compared to less prestigious MBA degrees, which are much cheaper, which have lower costs of living because you don't live in London or Paris, you know, or Singapore. So what I'm saying here is please do consider it very carefully. Do not take an LLM degree just because all your friends take one. This is my key point here. What you can also do, and I think this is the last point here, is, and I have to be careful, it's now exactly 1 hour and a half since we started, I think. You can get certified with an international organization. The best known, oh, wait. Okay. I think we can skip this because it's clear what everyone will answer now, because I did it the wrong way. In the interest of time, let's move on. The best known, I think, is the CIR, the Chartered Institute of Arbitrators. Harald, I understand you are an associate member. They have student membership as well. I used to be, for about 2 years or so, on the global steering committee of the young members group. So everyone with the CIR who is below 40 is a young member, and I used to be on the governing board for 2 years. So I know the CIR very well, and I have been a fellow for, I think, 8 or 9 years now. Harald, you want to add something?
Well, no, Harald, but I do agree with you that, you know, I'm a newly admitted associate to the CRB itself, and I'm feeling a lot of benefit as well by getting certified by the CRB. And I think, you know, it could definitely be one of the way for the audience today to, you know, understand further or build relationship even through this international organization, as you have done it previously as well, right?
Yes, I agree. The certification matters. If you can say I'm an associate member, or, you know, whatever the title is, this is something which matters. You can also put it after your name, the acronym, so it helps. At this point, I'm now finally introducing the BIAMC's student membership scheme. I don't wish to advertise it too much because I don't want this to be a sales session. But what I do want to point out to you, and I'm not exaggerating here, is that to the best of my understanding, we are the only organization which will not only allow you to get certification, but which also offers several career building courses, workshops, courses, seminars. This is what I understand makes us unique, and this is why I believe it's a huge advantage when compared to other organizations. So we have, for instance, a workshop specifically what skills are needed in international arbitration. We have a workshop how to survive your first year in a law firm. We have a workshop on writing CVs in the legal industry. We have a workshop on how to do interviews in the legal industry. All of that, we offer it on top of the regular courses on mediation, arbitration, and other forms of dispute resolution. So this is why I believe and I'm not just saying it because I'm advertising it, but I really do believe that it offers a lot of advantages. You can simply find out more about it by Googling BIAMC student membership. And with that, I move on. What you should also do, and what's the easiest step, and I challenge everyone to do it at this very moment, subscribe to our Instagram channel. Now, I have a lot of white hair, as you can probably see, so I don't have an Instagram account. This is, way too new for me. But I understand that subscribing is very, very easy. So I encourage you to do it right now. We also have a YouTube channel and we have a LinkedIn channel. I believe we can send you an email after this event with the addresses. What we have in particular, and that's why I'm mentioning it, and this is entirely free of charge, we have a program called My #1 Career Advice for Young and Aspiring Lawyers. So every Friday, a legally trained person, it's not necessarily a lawyer, as in someone working for a law firm, will make a short video clip and provide his or her #1 advice. Now, every piece of advice is related to the law, but it's not always about the law itself. We had, for instance, someone from Hagen Lovells, Indonesia, who spoke about finding your advocacy style. She's a dispute lawyer, and she spoke about finding your advocacy style. We had a lawyer 2 weeks ago from Paris who explained, specifically making reference to arbitration, how you should never stop learning. A lot of people make the mistake of believing, okay, I'm now graduated, now I'm done with the learning. Arguably, that's when the learning just really starts. So don't think that once you graduate, that's it. So I encourage all of you to subscribe to our social media channels, because when you do so, you will automatically be informed once a new video is posted. It happens every Friday, as I said. And I encourage you to also tell all your friends about it from law school, because the focus is not even necessarily on dispute resolution. It's a lot of the advice applies to anyone. A lot of the advice is on career building as such. The last advice we had was from a lawyer from Australia who explained how you can build your own personal brand as a lawyer. And while she focused on arbitration, everything she said holds true, generally, and not just in the field of arbitration. So this is something I really strongly advise you to do by all means, because it's free and you don't lose anything. Okay, finally, last point. Assuming we still have time, Harald, I think I have one more slide left.
Oh, we do have the time, Harald.
Okay,
I think we can continue.
Great. What qualities are needed in international arbitration? And as I said at the beginning of this webinar, I will discuss this from the perspective of a fresh graduate, of someone who just enters a law firm. There is no point in me explaining how you can become an arbitrator if you cannot become an arbitrator unless you have at least 7 to 10 years of experience. So this is why I'm speaking about this now. So what qualities are law firms looking for? When you work in the field of international dispute resolution, you should show flexibility regarding law and facts. What do I mean by that? I'm currently involved in several arbitration proceedings. In one of them, the applicable law, substantive law, is Indonesian law. In one of them, it's English law. And one of them, it's French law. I am qualified in Austria, but I still have to find my way around in these arbitrations. Now, I obviously work with translation of Indonesian law. It's not like you have to know the language in order to do it, but you must be very open-minded. It's simply not possible to look at everything from your own legal background, from your own perspective. This is why I said when you go abroad and you spend time abroad, your horizon widens, and this will allow you also legally to think more broadly. Your whole world expands. So it's simply necessary in arbitration to be open to new laws and to be ready to analyze something from a different background and not from the background of your own jurisdiction. You will sometimes work together with a law firm from a different country, and they will often be the experts on that law. But this is definitely not always the case. In all three arbitrations I'm mentioning now, there is no one to provide assistance. And you simply have to find your way around. Now, what about the facts? One arbitration of the three I'm mentioning, and there are more, but I'm just mentioning those three. One is in arbitration, one is in telecommunications, and one is in agriculture. Now, none of this field is related to any other, and it's simply necessary for you, when you want to do a good job in arbitration, to quickly learn about those industries, because you need to know about those industries in order to make good arguments. You can only make good factual arguments if you understand all the facts, and this often includes the industry. So you have to have flexibility. If trust me, some employers will specifically test you. During the interview, they will try to see how flexible you are. And when you say, nah, I don't really like numbers so much, you know, I can only deal with the law, it's not good, because numbers are important in disputes. You need to be able to determine the amount in dispute, you need to calculate damages, you need to calculate interest, etc. This is just one example. When someone says, what would you do if I ask you to, I don't know, to do a case in the military industry, and you say, I really hate the military industry because I'm a pacifist, you know, that may be your personal opinion, but you're not really conveying to your employer that you show this necessary flexibility. Harald.
Yeah, Harold, and I think when you said that we have to be flexible with regards to our knowledge on the facts, and you talk about how, you know, sometimes maybe some of us don't like to do numbers, you know, with calculating something. And I think it's very relatable, because one of the reasons why I went into the faculty of law, because I thought that there would be much calculations. But you see, as I understand from my previous competitions and you know, some of experience in law firms, I mean, at the end of the day, we should not only be comfortable with, you know, our background as a lawyer or as a legal person, but rather, you know, broaden our horizon and know about other facts as well, and other industries as well. And I think that's a very good point.
Right. It's you know, maybe our parents and grandparents back in the days, they could simply know about the law and this was it. But times have changed, and it's not possible anymore. Very recently, I drafted a letter where I pointed out, in an arbitration, where I pointed out that one stakeholder of this arbitration had given a number which was wrong by about 20%, which was higher than $5 million US. You know, that's just embarrassing. It's you completely embarrass yourself when you don't even get the numbers approximately right, and it's also for that reason that it's important. And you know, it's since this is held together with ILMS, and since at least you had already participated in a moot court competition, I was once involved in one in the oil industry. Like the background was in the oil industry, and it all spoke about damages. And then I asked, I was judging the final, so I deliberately asked very difficult questions, and I asked both sides to tell me what the price of a barrel of oil is. And none of them had any idea, not the slightest idea. And then I asked them to give an estimate. And it was just embarrassing. It left a very bad picture for both teams, and everyone who was sitting as a judge was frowning. So you could see that everyone who was sitting in a judge knew this, even though they had not prepared for this moot court competition. But they knew it because in their daily practice, they know that you have to know what's happening in the world, and that you have to know about the industry in which you're making a case. So this is why it's important. You have to be open to work with or against law firms from other countries. So culture matters a lot. You cannot say, well, I would prefer to communicate in Indonesian only, so I don't really want to work with that law firm. You cannot say, this is unfortunate, but you cannot say, I would rather leave the office at 5 p.m. when you work together with a US firm and they only come to the office when it's, I don't know, 8 or 9 p.m. your time. You have to show flexibility there as well. And yeah, you know, it sucks. At times it really sucks. And I hated it myself. I especially hated it when my kids were very small, when they were just a few months old. And I really wanted to get home, but I still had to stay back at the office. It's just the way it is at times. It sucks, but you have to suck it up. Sorry for so many sucks. And finally, my third tip is, or not tip, but what the qualities law firms are looking for, especially when there is international arbitration proceedings. You have to master English. Other languages also help. I think in Indonesia, in particular, Chinese would help a lot, because the Chinese invest a lot in Indonesia. But English is a must. Do not think that because you're not good at English now, it's going to be very hard to learn it. If you spend just 15 minutes every day, you will improve tremendously. I was speaking to my wife yesterday about English, and when I got to know her, which was in 2005, just to give you an idea how old I am, but we were both at university, so don't get me wrong. She was making a bit fun of a mistake I made in English, and she was totally right. I made a mistake, and it was a funny mistake. But back then, my English was really bad compared to my level now. And I'm totally not saying that my English is perfect now. I'm still trying to improve. And I do something specifically to improve at least once every week, even now, after having worked predominantly using English for, I don't know, 12 years. You know, all my professional life, I've predominantly been using English. And still I'm trying to improve because I still can improve.
Right, and I think it's a never-ending journey, you know, with languages because we use it every day. It's developing every day, and I think, you know, you cannot just learn one language and be done with it. I think you need to improve it day by day, so to speak, so
Right.
it sticks with your understanding. Yeah.
Right.
And I think, Harold,
yes.
yeah, if you're open, I think we have received some questions with regards
Yes.
to this specific slides that you were showing.
Mm-hmm.
You previously said that we have to be flexible, you know, with regards to other industries. So here, Faki is asking to you whether an experience in management or financial consulting can be relevant in a law firm or international arbitration work. What do you think?
Yes, it absolutely can. You know, any industry experience matters and is useful. It's both useful because you will understand the dispute much better, be it finance, be it construction, be it, you know, whatever it is. That's the one side. The other side is that when you try to get clients and you can, you know, the client speaks to you and doesn't have to explain anything because you fully understand. That's a huge, huge plus. I once had to learn in an arbitration about a plant to clean water. Now, this was attached to an oil rig, so they drilled for oil there, and attached to it was a mini plant for cleaning water. And I learned anything I could on how this works, etc., including the chemical formula and the chemical processes. I really delved into this. And then we met the client, and the client told, back then I was an associate at a law firm still, it's many years back. And at the end of the meeting, I went to the toilet once, and then the client told my boss, the partner, that they had never seen a lawyer who knew as well about this as me. And you can imagine how pleased my boss was. And at least for about 3 days, I could go home on time in the evening. Then it was back to normal. No, but the point is, it really helps. Now, to elaborate further on this, does this mean that you should first work in the financial industry and then become a lawyer? I would not go that far, because I think if you have 5 years of experience as a lawyer, it's always going to be better than 5 years of experience in the financial industry if you want to work as a lawyer at the end of the day. So don't misunderstand me, please. But if you work in a certain industry for a few years and then decide to become a lawyer, then it will definitely be beneficial. However, you may still have to start at rather at the bottom in a law firm. Just because you have 5 years of experience in the financial industry does not mean that you will start as a senior associate. You would still start as a junior associate. Okay, in the interest of time, oh wait, is there anything else? Any other open question, Hero?
Not yet, Harold, and I think,
okay.
Yeah.
Then we have the last question, and possibly we will publish something on this on the polls here. So we'd like to know if after having heard everything, you are interested in pursuing a career in international arbitration. Yes or no? I think it's, again, a fairly simple question, but we still want to raise it. Again, there is no right or wrong answer. Maybe now, after, and you need to skip this question, please, the one on the getting certified. After having heard this, after having heard what's required, what is useful, maybe you are of the opinion that it's not for you, and that's totally fine. You know, because that's entirely your choice. You shouldn't do something, you know, that you don't want to do. I will, since we're waiting for the poll, I will in the meantime thank everyone for joining and for their attention. If you have held back any questions, please ask them now.
Yes, Harald,
Yes.
and I think there is a question from
Yes.
Elizabeth.
Uh-huh.
She asked whether there are any specific qualities in a person that makes them more fit in arbitration rather than, for example, being a litigation lawyer.
Yes, I wanted to cover this originally, but then I noticed that I would go well over time, which I now in fact have. Apologies for that. We're 3 minutes late, and still one poll is missing.
Well, Harald,
yes.
I think you still have time since we are kind of combining within the Q&A session, the presentation.
Okay.
We're doing it along the way, so I think you still have time. Okay,
great. You know, I keep in mind that it's a Saturday afternoon. Yes, litigation is a very standardized process in comparison to arbitration. In litigation, you always have to follow the same procedure. At large, the process is always going to be the same. In arbitration, it's always going to be different. This is because you have different rules, you have a different applicable law, and also what is quite different is that you always have to adjust to your tribunal. When you plead to a tribunal that's predominantly, say, from East Asia, it's quite different than pleading to a tribunal that's predominantly from the USA. These are just examples. So working in the field of arbitration requires you to be much more flexible. This is my view. You also have to adjust to the style of the other law firm. That's what I meant by working against another law firm. If you come across a firm from the US, they will be not necessarily, but possibly extremely aggressive in their cross-examination. Now, this is probably, I don't know how it works in litigation in Indonesia, but it's definitely not as aggressive because it would be insulting in Indonesia to ask so aggressively. So all of these are issues you only have in arbitration. You do not have them in litigation. And this is what I say are the key differences, the flexibility you have to show.
Right, and Harald, I think we already have the result of the polls, and I am happy to see that almost, you know, those who voted chose yes to the question of the polls. So I think your explanation has pretty much given them the, you know, the information for at least for them as a basis to see that they are actually interested in pursuing further their knowledge on international arbitration.
Or at least I didn't make everyone scared.
Well, yeah.
I hope all those who voted have already signed up to our social media channels to, at a minimum, get the, you know, the your number one career advice vlog, because this is definitely going to help everyone. I'm wondering, Hero, if we have any additional questions at this point.
At this point, we have not,
okay.
Harald. And I think I would like to encourage the audience, if you still have any questions, it's better for you to ask now rather than cry later when you don't have the chance anymore to ask Harald.
Maybe in the interim, what I can speak about is, so I made the comparison between litigation and arbitration. Another very popular field from my experience is corporate/M&A. A lot of law students are interested in this area, and there's a lot of lawyers in that field. I don't want to take sides, but I'm obviously biased. If I thought that M&As were the most interesting thing, then I would not do what I'm currently doing. I'd be an M&A lawyer. What I can tell you on the hard facts is that there is tons of pressure on M&A lawyers to lower their fees. This is because in recent years, we have seen a lot of new organizations enter the M&A industry, which are not law firms. In Indonesia as well, you have big accounting firms. I think all of the big four exist in Indonesia. I know for sure that E&Y, Ernst & Young, exists in Indonesia. These accounting firms charge much lower rates than law firms do. And there has been a very clear trend starting in the US, then moving to Europe, and now also having moved to Asia, where those accounting firms are more and more retained to do the less complicated work in M&As, in particular the due diligence, which by less complicated, what I mean is it's not necessary that you are a very experienced M&A lawyer. But this is a big problem because it's often this less complicated work which has generated most fees for the lawyers and for the law firms. So there's a lot of pressure on the fees. This would be one reason to choose arbitration over M&As. My personal experience has always been that M&As are much less creative. So you cannot work as creatively, so to say, in M&As as you can in arbitration. And M&A dispute, of course, allows you to structure deals in a certain way, but after you have done it for a few years, I mean, that's also what my friends tell me who are M&A lawyers. It becomes quite repetitive. I'm not saying everything is the same, and above all, I don't want to say it becomes so easy and simple. This is not what I'm saying, but it's much more repetitive than arbitration is on average. On average, in arbitration, it is necessary to a much larger extent to learn and understand about the industry that's behind the dispute, which again has nothing to do with the law, right? That's the fact, so to say, surrounding the arbitration. But right. This industry knowledge is, to me, what makes arbitration so interesting. I right. do like the procedural problems, and I find the substantive law problems somewhat interesting. But what I find much more interesting is, to learn how you clean the water after you pump out the oil from Earth. That's much more fascinating to me. Harald, you want to add something?
Yeah, right, Harald. And I think, maybe is it safe, you think, to assume that arbitration gives you new challenges every day compared to, other sector in the legal industry, because maybe the nature of the conflict could differ on each cases, and sometimes the dispute will be on the payment of the goods, sometimes the conformity of the goods, and even sometimes with other part of the transaction. So it could be diverse. It could be different on each time you tried cases in front of arbitration compared to some of the corporate work like M&A.
This is true, yes. Although in corporate work, you have share deals, you have asset deals, you have mergers, you have acquisitions. I mean, there are also numerous types. But what I think is different in arbitration is that you very often have an international element, which makes it completely different. That's the difference. In an M&A deal, or in any deal in the corporate world, it's the lawyers who can decide the applicable law, because this is the law that will be agreed upon, and the deal is going to be structured accordingly. Very, very often it's the law of England and Wales. In arbitration, you simply get the contract on your desk, and you open it and you already worried what the companies which drafted it, how they screwed up, what is causing difficulties, where the mistakes are. And I think to that end, there is much more diversity, a broader range. And to that end, there are a lot more surprises than there are in the corporate world. But again, I don't mean to give the impression that one is better than the other. It's just different. But to those who, I mean, you mentioned, Harald, you mentioned challenge. Those who like challenges, I think they will, on average, again, it always depends, but on average, they will prefer international dispute resolution.
Right. And I think there's another question coming from me, Harald, and as I heard that you are interested in the procedural issues of arbitration, safe to say, rather than the substantive one. And I think, as I'm doing my thesis on procedural law, it intrigues me to know what makes you more interested towards procedural law.
I think what makes a good arbitration lawyer is that an arbitration lawyer is an expert in procedural law. The reason I like it is that if you win on the procedure, very often you don't even go to the merits. I think a lot of lawyers doing arbitration do not know enough about procedure, as strange as this may sound, but it's true. I don't know. I cannot really explain. I think I'm a nerd, and I see the beauty in procedural arguments. To me, it's something that's just really beautiful. Well written or well argued procedural reasoning. It's really beautiful. It's hard to explain why I like it better.
If it makes you a nerd, then it makes the two of us.
Welcome to the club. And don't worry, even though I'm a nerd, I could still get married.
So guys, if you are passionate on procedural law, or maybe you're interested, it's okay. We're doing fine here. And Harald, I think we have a question. As I'm aware, as of this point, Indonesia is still lacking on figures that is well known in international arbitration. Every time that I open a journal, every time I open a book, it's lacking Indonesian figures. So do you think there's any way for maybe the audiences who soon to be a law graduates to improve this situation, whether they can contribute to become a prominent practitioner in the international arbitration from Indonesia? Do you have any tips and anything for them?
It requires a lot of hard work. I'm possibly, again, overgeneralizing, but on average, based on what I have seen at international events, Indonesians, and again, this is an average. Please don't get me the wrong way. There are always exceptions, and what I have seen may also not be representative. But Indonesian lawyers would be less interested in speaking to international practitioners. This is what I have experienced at international conferences, both in Indonesia and outside of Indonesia. When I compare it to Singapore, for instance, they are a lot more aggressive when it comes to the networking. And unfortunately, in order to become an arbitrator, being good in arbitration is only one requirement. I think it's much more important to have a very vast network. This is going to get you a lot more appointments ultimately than being an excellent arbitrator, because unfortunately there are quite a few bad arbitrators out there. That's also the truth. So it does require extra efforts. That's always the case. You know, you will not become a well-known practitioner by sticking to your own acquainted world. You have to go out. You have to connect with other people. You have to speak at events. You have to publish. And above all, you should not be shy and believe that you have nothing to contribute, or that your English is not good enough, or that you don't know enough. You shouldn't be arrogant, but also not shy. I think that's the best advice I can give.
All right. Yeah, and I think I would agree with you, you know, to some extent. A lot of Indonesians still, I don't know, in my experience, still feel a little bit insecure, whether about their language barrier, and that is why they are feeling not very confident in, you know, building relationships with people from abroad who uses English on daily basis. And I think if they could encounter just this issue, I think it could open a lot of opportunities for them in the international arbitration sector. And I think,
Right.
Harold, seeing that we do not have any more questions, if you don't have anything more to convey, I think I can conclude this session.
Maybe just brief final remarks. First, again, thank you very much for the great moderation. Thank you to the organizers. Thank you to you out there, everyone. Thank you very much for joining. The point I want to conclude on is it's a fascinating field and area of work, and it's great if you want to enter this field. Do keep in mind that it always requires work and efforts, but also that Rome wasn't built in one day, and no arbitration career was built in one day. So it's a continuous effort. It's a marathon rather than a sprint. I like saying that on several fields, and it's true here as well. If you continuously and consistently work on the points I discussed today, get better, learn, then you will not be better 2 weeks from now, or maybe even 2 months from now, but 2 years from now, you will be a different person than you are today. Thank you very much.
Thank you very much, Mr. Harold. Yeah, I think I would agree pretty much with that conclusion. And I think to summarize what Mr. Harald has presented to the audience, to refresh again their memories from the beginning of his presentation, I think on the first part of his presentation, we have learned about the many forms of alternative dispute resolutions. We have learned about which one of the forms are the most common form for business disputes and for international disputes. We have also learned that in terms of arbitration, there are more actors other than only arbitrator and the parties. We understand that there is the secretary of the tribunal, there are expert witness or even fact witness, there are court reporter and arbitration institution. And I think there is a lot of opportunities that the audience today can explore more on those professions rather than, you know, only the only go back to the general understanding that arbitration is about the tribunal and the parties only. And I think on the second part as well, we have heard the stories about how Harald came to get to where he is right now. You know, he was not intentionally became an expert as we know he is right now in international arbitration. However, he do improve himself every day, and you know, as he said previously, everyone has their own story, and I think I can again refresh your memories on several things that Harald has spoken with regards to what we can do to improve outside of our education. That is, first, that we have to be able to show our employer that we are better than the other candidates. In this sense, is that we have to show them that we have concrete actions that we have taken in the past when we're learning, that we have done something, instead of only saying that we're passionate about certain things. And that being said, I think one of the things that we can do to prove our concrete action is by participating in a moot court competition, participate in an essay competition, or even publish an article, as we've heard from Harald, that it is not impossible even for students to publish their article. And we can also join young organization. And of course, this is one of the emphasis that we want to put is on relationship building, as we know that there are a lot of aspects with being professionals in arbitration, but relationship building is one of the most important. And I think with respect to our education, we have heard how Harald talks about how we could get specific courses from universities and his pros and cons on taking an LLM, as well as to get a certification. And as I understand, you know, we can get a certification from the CRB like me, or even from the BIAMC. As I understand, you know, it even interests me that BIAMC offers not only certification or lectures on alternative dispute resolutions, but as well as how you can build your career on that. And speaking of certification, I think since you guys are receiving certificates out of this webinar, you could upload those certificates on your LinkedIn, and don't forget to tag ILMS and BIAMC, of course, on that. And I think on the last part of Harald's presentation, we understand that the qualities that are needed in pursuing a career in international arbitration, that is, we should be flexible regarding our knowledge on the law. We should not only be restricted with, you know, Indonesian law, we should also be quickly adaptable to other countries' law. And also with regards to the facts, we should not only, you know, familiar with the legal industry, but as well as other industries. And we should be open to work with or even against other law firms from another country. As Harald have said, the consequences of, you know, in international arbitration is that sometimes the time differences could be one of the barrier, but that's one of the consequences that we should accept if we are serious and want to pursue international arbitration. And of course, we need to improve our skill on English and even other languages. And if I could, you know, mention where on the first part of Harald's presentation, he said that his task here is to, you know, lay ground on alternative dispute resolution and demystifying a lot of conception, wrong or misconception about alternative dispute resolution professions. And I think I could safely say that Harald has done a great job on that, and task has been accomplished. So I think that's it, or the summary from me. So go back to you, Justin.
Great. So as we approach the end of the event, on behalf of ILMS Fakultas Hukum Universitas Indonesia, we would like to extend our deepest gratitude toward Dr. Harald Sippel for filling in today's webinar, as well as Heru for moderating and providing both of their insights on the various career pathways in ADR.